and a woman and any of the persons mentioned in part 2 of the said schedule, another class of relatives, are within the degrees of prohibited relationship. There is a prohibition to marriage. Correct, my lords? Now the argument was
Cumulate.
to apply both to both.
Cumulate both.
Correct, my lords. So the first, that would be necessarily rewriting.
Right.
The second proposition which I must mention here at this stage itself. Lord, would your lordships, I'm posing a question to myself, would your lordships read a particular enactment in such a fashion that it applies in a particular manner to one class, that is heterosexuals, and in a different manner to different class, namely homosexual, I say same sex, the broad category, my lord, we have identified. My lord, that exercise, my lord, may not be a permissive interpretative exercise
So
to create a class within.
Use it. This is what the gesture that I made was. When I'm looking for same sex, I don't wear this. But when I'm looking at heterosexual marriages, I look at it, they act like this. So is this two-way or three-way switch possible in interpretation?
Correct. So, my lord, in my respectful submission, the statute cannot be read to mean A for some class and B for some class. And second, my lord, this is my apprehension, and I must, my lord, share at the outset. And kindly, my lord, examine this a little seriously. My lord, why this degrees of prohibited relationship? I'm not on, my lord, reworking or restructuring.
By the way, interestingly, are these degrees of prohibited relationships pretty much the same as that would are they lifted from the Hindu Marriage Act, or where do they come?
Sagotra and Sapinda relationship.
Sapinda is absolutely.
They are now codified, my lord. Because, my lord, apropos, my lord, Justice Bhatt's query yesterday, this entire debate.
Itemized elucidation in the
Things also.
Yes.
One is the Sapinda, which is you go to the same ancestor, lineal ancestor, and the male linear and the female linear. That originally Shastrik it was 7 and 5. Now in the Hindu Marriage Act it is 5 and 3.
Correct.
Section 5. That is one part where you're talking of uterine blood, etc., where there is blood relationship. There is non-biological relationship also when you're talking of in-laws. So, relationship by marriage. Even there is proscription on that.
That is also prohibited.
It is also there. And this applies equally to all religions and all castes.
My lord, my worry is different. My lord, at this stage, I am not flashing it. And kindly, my lord, listen to this concern, my lord, very carefully. My lord, what is the fundamental argument of the petitioner, which I respect the argument, that it is my right to choose my sexual orientation. Choosing a sexual orientation is
not right to choose sexual orientation. They say sexual orientation is given to me.
I'm on Nautage.
I'm entitled to my autonomy by virtue of my sexual orientation.
Correct.
And a recognition that goes
sexual
with
orientation is not a matter of choice, but a matter of immutable features.
My lord,
that's the argument.
My lord, there are two ways, my lord. There are two different schools of thought. One say it is acquirable also. Another say that it is inbuilt in the person when a person is brought. Let's not go into that. I'm slightly on a different point. Lord, freedom of sexual orientation is held to be a fundamental right. Someone is attracted, a man is attracted to man, that is considered to be his privacy issue, and he can enter into that kind of a sexual activity the way he thinks he gets the maximum satisfaction. Lord, that's my lord broadly. My wordings may not be accurate, or my lord may be proper also. That's that Nautage Johar. Lord, kindly visualize a situation after 5 years down the line, based on this very thing, that from the beginning, I am attracted to those persons who are mentioned in the degrees of prohibited relationship. Incest is not uncommon in the world, and world over incest is prohibited. that I am attracted to my sister. I get, we are consenting adults. We are entering into activities within the Lord privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, Lord, I'm posing a question to myself. Can someone not challenge this definition itself? Why this restriction? Who are you to decide with whom I have my sexual orientation? It
would
may be, my Lord, a little
that would be
far-fetched.
far-fetched. That would be farfetched.
Lord, we used
it's
to
obviously a
treat,
reasonable restriction. You can't have.
we used to treat even this as far-fetched.
But you know, Mr. Solicitor, sexual orientation or your autonomy as an individual can never be exercised. All aspects of marriage, including the entry into marriage, the prohibited relationships, the grounds on which marriage can be dissolved, these are all subject to regulation by law. So it may be very far-fetched for anybody to even argue before us that that orientation is so absolute that I can therefore commit an act of incest. No court will ever
But suppose
even countenance it.
polygamous marriage.
Forget about sanctifying it, even
Somebody can challenge, my Lord, the bigamy provision.
Polygamous marriage, that's again governed by personal law, right? I mean, on the
I'm not on personal law. I'm saying, my Lord, if I say that my choice is polygamy, bigamy, the state has no right to
Your argument perhaps could be more, I would say, if you're leading up to that, one can understand it. That these are universal rules. I think we can all agree that these are universal rules. Now, as long as they were not codified, they were accepted. And that was the law, that was the norm, that they had a normative effect. Why did the state get into it? The states thought this as a universal norm. Now, therefore, I think if you're building up and saying there is a state interest in this relationship, one can understand. What if you're driving at that this is where the state comes in?
But that's my submission.
I think their position too was conceded that when it comes to age also that there is a state interest. So there is no field which is completely autonomous in that sense.
Correct.
Even within the marriage bond, there are certain interests of the state which are legitimate, let us say.
Lord, that is, Lord, in the second limb of my submission is going to be that state has no business to regulate social personal relationships. It is only in exceptional cases where the state
that would be also very an extreme statement of law if they have made that statement.
I'm saying something else, Lord. I'll just complete that. State has no business as a proposition to regulate any social personal relationship. That statement your lordships are saying is not it's an absolute statement. But I'm on an extension of that statement that the state can regulate certain relationships if the state feels that it's in legitimate state interest to do so.
But of course, yes.
Therefore, marriage was not a regulated social relationship. But the state, in its legislative policy wisdom, decided that we will regulate, and we can regulate only if we recognize, and therefore, under the Hindu Marriage Act or any other marriage act, we recognized and regulated. So, therefore, that's a legislative choice made. My Lord, leave it at that. But, my Lord, again, my Lord, I'm insisting, my Lord, that my apprehension may, I wish it's wrong, but may perhaps not be wrong after, my Lord, few years. When your lordships were hearing Navtej Johar, all these arguments were made. The central government, my Lord, said that we leave it to the wisdom of the court so far as the decriminalization of Section 377 is concerned. But I specifically added in my affidavit that this has nothing to do
with marriage.
Future right of marriage, inheritance,
Absolutely,
etc.
no question about it.
And I'll just read, my Lord, from page 1.
Solicitor, don't even label that. You have said that. No, we accept your point on that.
So, my Lord, a step from step 7 to 8 may lead from 8 to 9. That's what I am just, my Lord, putting a word of caution. I'll, my Lord, further. I'll go further.
7 to 8, where you're saying will lead to 8 to 9, that'll be actually 8 to 15.
You can say.
And none of us are looking at step 8.
Social relationship.
The current scenario, Mr. Mehta, or also in the future.
The arguments, the way they are read for marriage.
Yes.
and I'm saying this with a sense of responsibility, can be made, whether
Mr.
accepted or
Mehta,
not is
I
one
don't
thing,
think we need to.
for challenging incest prohibition
But
as well.
Mr. Mehta, we don't have to labor the point that the state can regulate even social relationships. Once a relationship between a parent and a child, can the parent say, I have absolute control over my child? No, the state says you have to send your child to school.
I leave it at that.
There's an obligation to make sure that your child goes to primary school. That's a relationship between a parent and a child, but we are all subject to the fact that you have to send your children to school. You have to get your children vaccinated. So these are obviously there.
Now coming back, my lord, to that, your lordships would be required to rewrite. Coming back to the main thing.
Let's go and
see, my lord. Full blood, definition of full blood and half blood. Your lordships have read, my lord, as hypothetically as requested by them, man, woman, different categories of prohibitions, but your lordship said both prohibitions would apply, and your lordships would bear in mind the petitioners do not represent everyone who is in this particular class. Somebody may say that, no, I don't agree. Why should it apply to both of us? So it would be a risky thing to do. But now full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife.
Hindu marriage act. Oh, thanks.
Special marriage act.
You're reading from Hindu Marriage Act or
It's a special marriage.
Special marriage.
Special marriage act. Two
Explanation two.
explanation.
Yeah.
That's right.
Yes.
Full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor, that is male, because the next word is by the same wife, and by half blood when they are descended from a common ancestor but by different wives. We can never reconcile this provision because it says biologically one man has given birth to a child through a biological woman. That's what they say. Number two, Lord, marriage between lesbians. This provision will be redundant because she can't have, Lord, full blood. Even if, Lord, there is a child from artificial insemination, it would not be a full blood child. So merely changing man and woman into persons will make many provisions not reconcilable at all. And, my lord, this full blood, etc., will have an inevitable impact on the succession. I'll show. Yeah, my lord, your ladyship's mic is not working.
Actually, then you also see the Hindu Marriage Act, which section 3G.
Yes. And your lordship may for the time being take it from me that Hindu Marriage Act will apply. I'll show how it applies, even to Special Marriage Act.
Section 3G.
3G. Degrees of prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is
Absolutely.
a lineal ascendant of the other. I'm sorry. My lord,
3D. You're talking
2G, 3G.
3G.
Degrees of prohibited, does your lordship get so?
Yes.
Prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one was the wife or husband of a lineal ascendant or descendant